5 seconds to go. Start. Admittedly, the respondent was initially appointed as assistant chargeman in the Rajasthan Agriculture Engineering Board, from where his services were transferred to the Rajasthan State Agro Industry Corporation, where he worked till 12th April 1977. Thereafter, he was appointed Assistant Director Agro Industries in the Industry Department and submitted his resignation from the Rajasthan State Agro Industry Corporation. Admittedly, the service of the respondent under the Rajasthan Agriculture Engineering Board and the Rajasthan State Agro Industry Corporation was pensionable as found by the High Court. Dr. Manish Singhvi, learned senior counsel, appearing on behalf of the petitioners, argued that the High Court had misconstrued Rule 25(2) of the rules. He argued that resignation entails forfeiture of past service with the Rajasthan State Agro Industry Corporation for the purpose of pension. The respondent resigned from Rajasthan State Agro Industry Corporation to take up appointment as Assistant Director Agro Industries in the Department of Industries in the state of Rajasthan after being selected through the RPSC. The division bench and the single bench of the High Court have concurred. The effective and concurrent factual finding of the division bench and the single bench of the High Court that the respondent had resigned with proper permission to take up another appointment under the government for which he was qualified does not call for interference under Article 136 of the Constitution of India. Dr. Singhvi emphatically argued that the writ petition was filed by the respondent after 6 years. The respondent was appointed to a higher post in the industry department. As such, his past employment was inconsequential. There was no proof of prior permission before resignation from Rajasthan State Agro Industry Corporation. Dr. Singhvi submitted that the appointment was a fresh appointment for which past service was inconsequential. Dr. Singhvi emphatically argued that in service jurisprudence, resignation necessarily leads to cessation from service and entails forfeiture of past service. The stand taken by the state is arbitrary, unreasonable, and misconceived. The state is bound by the fundamental rights of its employees under Articles 14 to 16 of the Constitution of India. It is now well settled that arbitrariness violates the right to equality under Articles 14 to 16 of the Constitution of India. There can be no doubt that resignation from service may entail forfeiture of past service. However, Sub Rule 2 of Rule 25 of the rules carves out an exception. The said Sub Rule clarifies that a resignation with proper permission to take up another appointment, whether temporary or permanent, under the government shall not entail forfeiture of past service. At the cost of repetition, it is reiterated that the respondent was selected through the RPSC. He applied for the post of Assistant Director Agro Industries while he was still in service of the Rajasthan State Agro Industry Corporation, which is also an entity fully controlled by the state of Rajasthan. The respondent, having retired after working for about 26 years, the petitioner state cannot raise the question of proof of prior permission before resignation, more so when the appointment had been made through the RPSC to a government post. Stop.